Question. How long does it take to set up a common law trust? Answer. A few days to a week, from the time that trust writer Randall receives your order. Typically it can be 3 days. But it depends upon questions he will ask you, your answers, his workload, how fast you respond, what special documents may be needed, customizations, unique arrangements, etc. For example, he might make you settlor, grantor, and beneficiary, or he might make you trustee, depending on your particular use of the trust, intended relationship, and availability of friends or family members to fill any of those roles. Sometimes a client is asked to find someone who is willing and qualified to play the role of trustee, and sometimes clients can take longer than expected to negotiate that arrangement with their friend or family member. So that timing depends upon the client, not upon Randall. If the client plays the role of trustee, then a decision has to be made as to who will fill the roles of settlor and beneficiary. This is all arrived at in one-on-one discussions with Randall, and then it is up to the client to decide. Once all this is clear, Randall can basically produce the trust documents within 1 day. Question. What is the difference between trusts and other legal entities based on common law, and ones based on statutory law? Answer. Statutory law consists of millions of laws. They change every year and are so numerous and complicated that they require well-paid lawyers to keep up with them. They have created a whole industry of lawyers that parasite off society because of it. Such laws are generally designed to benefit the few at the expense of the many. The lawyers, the politicians, the big corporations, and the cabal's favored interests. Legal entities set up under statutory law are subject to those millions of laws, and require expensive and complicated legal expertise to defend them. Common law, by contrast, has been around for millions of years, and will continue to be around for millions of years. It rarely changes. It's basically, don't lie, don't steal, and don't violate the rights of others. It is the closest thing to natural law, or universal law, that is active in human affairs. It was the basis of the U.S. court system until 1938. It is still the underlying authority, and is now returning in force. Witness the work of Kevin Annett and others, to expose the Pope using common law courts. Trusts and legal instruments that are created under common law have far greater freedoms. They are subject only to the common law, and are the sovereign and immune from the ever-changing statutory laws. They can go on generation after generation, well into the Golden Age, and flourish because they're based on what is timeless. Question. Do I get an EIN for the common law trust? How long would it take to get that? Answer. For others reading that question, the EIN is for those who wish to open a bank account for the trust in the United States of America. It stands for Employer Identification Number, and even if you have no employees, the trust still needs to get the number from the IRS, for banking purposes only for those living or banking in other countries. Each country may have its own national business entity identification number that may need to be acquired to open a bank account in that country. You only need the EIN, or equivalent number in whatever country you are in, if you are going to open a bank account for the trust. The EIN is for banking purposes only, not for filing tax returns. Do not file any tax return for the trust. The EIN is required by the banks in the USA for opening accounts. The EIN is very simple, easy, and quick to get, and it is free. It is done online on the IRS website, and Randall can show you how to do it. Once the form is filled out, it just takes a few minutes or seconds for the system to generate it. Question. One thing that concerns me is simply that, as you mentioned, this trust is not understood by lawyers. It sounds like if there is ever some problem, the only person that could deal with it is your friend. I wonder if he goes away, where that leaves me. What or how would a situation like this be handled with this setup? In other words, I am concerned that only one person understands this and handles this type of trust. Answer. It is incorrect to think that it is understood by only one person. There are hundreds of thousands and perhaps millions of people throughout America and the world who use such trusts and understand them. While it is true that the science and art of such trusts have not been taught in the cabal-influenced law schools, and thus perhaps less than 1% of the bar-licensed attorneys understand them, there are a few There are more non-bar member common law lawyers and paralegals who are educated in them. In essence, it's a simple contract between the settlor-creditor and the trustees. It is handled like any other contract between 2 or 3 people. Bar licensed attorneys want you to use theirs, so most of them give the common law trusts a bad rap. Yet many of them sell their versions online as asset protection trusts, irrevocable trusts, etc. While my friend Randall is the best in America that I've seen, there are many common law professionals around the country who understand this category of trust. We would certainly miss the quality of Randall's work if he were to retire or become unavailable. But there will always be others who will carry the torch. I've known Randall since the early 1990s, and he isn't going anywhere anytime soon. It is highly likely that before he becomes unavailable for further consultation, he will have informed us of people he has trained, or who think like he does, in whose care he can leave us. Question: what your friend does sounds very good to me, although all the setup sounds like a total life makeover for me. Answer: no, it is not a total life makeover. All it is acquiring a wonderful instrument with which you can do many things. You don't have to do anything in particular with it. It's entirely up to you. Neither Randall nor I can advise you what to do with it. But I'll share a simple thing that can be done with it by anyone who acquires such a trust. One can do all banking, business, and commerce in the name of the trust. That way, when customers or clients pay for anything, or one receives money or payment for anything, it goes to the trust. For non-taxpayers, filing is not an issue. But even for filers, one would have no income in one's personal name to report. So even if one files, it is more possible that one may not owe anything. The trust can pay all one's bills, as well as whatever other distributions one designates, assuming sufficient money has been put into the trust, such as humanitarian donations, investments, business expenses, etc. One can write checks out of it the same way one would out of one's personal or corporate name if one had no trust. One can use the Visa or MasterCard debit card to withdraw cash out of it just as one would do in one's personal name. Thus, the reason I say it is not a total life makeover is it is not as complicated as you seem to be imagining. It's really very simple. You could just continue doing everything you were doing before. The only difference is, now you could be doing it in the name of the trust. Question: I would like to see what a trust looks like. Any site? Answer: your trust will be emailed as a Microsoft Word document attachment. Then it is recommended for you to print it on paper, if you wish, and insert it into a 3-ring binder notebook. This is because over time, many of the documents being added to the trust will have original wedding signatures, and sometimes notarizations on them. In addition, it is always good to have a hard copy, in case anything happens to your computer. Randall would only post-mail something to you if his signature is needed on anything. The main corpus consists of about 30 pages, but many more pages will be added as the trust develops over time. Plus the manual is about 15 pages. Bigger is not necessarily better. If the trust had 100 or 300 pages, it might contain a lot of unnecessary stuff that would make it more complicated than it needs to be. In this case, a trust with shorter text and lesser pages is actually more powerful and beneficial, because we have distilled the essence of the best legal and asset protection principles down into the most concentrated and user-friendly form. These materials are proprietary and are not published on any website anywhere. If you find any on a website, it would be very advisable to avoid using them, because Randall and I have decades of experience in eliminating so much of the nonsense out there and retaining only the trust documents and language that are most essential, correct, and beneficial for everyone concerned. Further, you wouldn't want to use anything that has been exposed to the public. The corpus of the trust is very private. It is never to be shared with anyone except your closest family and friends and/or whomever you may bring into the trust as any kind of officer or partner. Only a few pages are to be shared with the bank, the minimum necessary to get an account open. Randall will show you which pages. All the rest of the trust is never to be shown to any institution or agency, without the consent of the trustees. The privacy of it is one of its protections. That's why you really don't want to be asking me for a website where you could see the trust. I can send you an attachment of a trust indenture generic title page and first page, if you wish, so you can see what they look like. That's all I am at liberty to show you at this time, until you have become a paid and registered trust client. Question. I have some concern about doing business over the phone to Hawaii. Answer. Why? Most people shop online from around the world. You are not doing anything illegal, unethical, or that would need to be hidden. Other than not showing most of the actual trust contents to most outside parties, the fact of setting the trust up and having a trust is no secret. After all, if you're going to bank with it, you make its existence known to the IRS to get an EIN, or for those in other countries, the equivalent business identification number from your tax agency. The IRS will have the trust name, your social security number if you are going to be the trustee and signatory, and other pertinent details. Randall will provide the directions and instructions for you to make the application. It only takes a few minutes to get the EIN. The EIN is for banking purposes only, not for filing tax returns. The IRS will never ask you for a tax return on the trust, so don't volunteer it. So if the IRS or tax agency in your country knows all about your trust, who else would you wish to hide your communications about it from? Do you think the National Security Agency will be listening to the phone calls or intercepting your emails? Who cares? Let them listen. It may bore them to death. There is absolutely nothing of any great interest to them in your getting involved with this. We have much to protect, but nothing to hide. We walk into the bank with a few pages from the trust and open a bank account. We provide our SSN as a signatory, and the EIN for the trust. The bank has all the info about the trust in their computer records. So this is all done in the full sunshine of daylight. Randall and his clients talk openly all the time on the phone about every intimate detail of the trusts and related business affairs. We email such details back and forth likewise, without encryption. I've been involved with these trusts this way since 1993, and Randall since sometime in the 1980s. So have countless other people worldwide. We've had no problems. So what are you worried about? Question. This common law trust seems to be designed specifically for U.S. citizens. Answer. It wasn't designed for U.S. citizens. It existed long before the USA ever came into being. It is ancient. It was simply adopted and utilized a lot in America, since more people from the USA seem to use it than other countries. More U.S. laws have been located to authenticate it, but it can be equally authenticated in any country. It is used throughout the world, everywhere. The common law exists, and has predated statutory law. It is the right of all human beings everywhere to enter into private contracts with each other as long as doing so doesn't violate the rights of anyone else. This is surely verified by numerous Supreme Court cases in most countries. Also, although common law instruments are better than statutory ones, in general, Randall also arranges for statutory entities to be set up if you need them, whether they be corporations, foundations, IBCs, statutory trusts, or whatever, in any jurisdiction in the world. And he can help you structure asset protection layering between them, if you wish. Question. But I am a Canadian citizen and most of my close family are EU, European Union citizens, German citizens and not US citizens. Answer. That's absolutely fine. It is equally applicable to all countries. That is the appeal of it. The common law is universal, and therefore any trust based on it is more simple, more flexible, and more international than statutory entities. Question. U.S. banks are obligated to inform the Canadian Revenue Agency about all my assets held in the U.S. banks. This question applies to readers anywhere in the world, outside the USA. Answer. The assets in the trust will not show up anywhere as being your assets. They will belong to the trust, not to you. Question. Since we are not able to meet Mr. Randall in person and he has no webpage, no proven records of successful practice, how can we be sure that our assets, properties and business would be safe in the trust that he designs? Answer. Meeting Randall in person would not guarantee that the trust he sets up for you would protect you. If Randall had a website, that too could be misleading, as many websites are. It is not the meeting or the website that gives credibility. I can assure you that the trust will protect you, and that Randall is honest and of integrity. But you also don't know me. I understand. The way that you can know is by understanding some very simple things. 1. No government anywhere has any right to prevent you from entrusting your assets to anyone else, including a trust. 2. If you transfer ownership of your assets to another entity, you no longer own them. If you no longer own them, no one can take them from you. 3. The trust that Randall sets up for you is written in plain, simple, easy to understand English. It is not complicated and it does not require a law school educated attorney to understand. You can understand it yourself, just by reading it. In reading it, you can see very plainly that it protects you. It protects your assets. It gives you control, removes liability, and allows for nearly infinite flexibility. 4. This flexibility allows you to structure it and operate it just about any way you want to as long as you aren't violating the rights of anyone else. This means that you are in the driver's seat and you won't need to trust me, or Randall, or anyone else. If you can trust yourself, you will see in the trust document that it will give you whatever arrangements you want. Question: would Mr. Randall help us to understand how payouts for our employees will be taken care of in a precise, timely and safe way? Answer: yes. Randall will be available for ongoing consultation. However, you don't really need Randall to answer a thing like that, because you would administer your affairs pretty much the same as you would without the trust. The only difference is you are doing it in the name of the trust. Otherwise, the rest of your individual, business, commercial, and investment affairs are the same. The only time you would need to consult Randall is if it specifically pertains to any aspects of the trust that are perhaps not already covered in the trust manual. Question: how can we be sure that unauthorized people will not be able to access our trust bank accounts? Answer: most of the answer to that question would come from other sources, because the issue would not be with the trust. It would be with other policies of security at the bank or mechanisms of security on your computer. The trust itself only authorizes the people to have access to the bank account whom you designate. If you designate no one other than yourself, then that is the way it will be. You can be the sole authorized signatory on the bank account for the trust if you wish to be. If anyone else were to access the bank account without your permission, it would not be the fault of the trust. It would be the fault of insufficient bank security or insufficient security on your computer, your identity, etc. This writer has been using this type of trust since 1993 and banking with it since 1996. So have many of my friends. I have done commerce with them, investments, business, banking, international transactions, all kinds of things. I have never had a problem with them. If they're designed and operated correctly, you will have no problem. And they have gotten better and better. The version Randall is providing now has improved, year after year. He keeps adding refinements, adjustments, and improvements. Question: we would most likely need to attend one of your and Mr. Randall's special introductory workshops in order to get a deeper understanding about what are the benefits of the common law trust. Answer: believe it or not, we don't conduct workshops. You are overcomplicating things. You need to relax. It is really simpler and better than you seem to be imagining. We think companies that run big promotions of trusts or other legal entities with seminars and so on actually do less good for their clients than Randall is doing. Precisely because he has so few clients, and is so little known, he is able to act more like a friend and give more personal attention. Companies that run workshops, on the other hand, are less personal, and will be less caring, with less personal concern or attention. Randall has an excellent history of avoiding trouble, and his clients have generally avoided problems with the trusts as well, due to the proper design of the trusts, and the recommendations Randall provides for proper operation of the trusts. You are more fortunate than you may realize to have the offer to be introduced to Randall. He is not famous or high profile and we want to keep it that way. Neither he nor I have advertised his services. I was invited a few times to speak on certain conference calls about the credit card debt cancellation and the trusts. But frankly, I didn't want to be going that high profile, talking to thousands of people. But people kept asking, and so I finally consented. But otherwise, I have not publicized Randall's services, and neither does he. You are very fortunate to learn about him. If you found information about this on a website, neither he nor I posted it. Someone else posted it, usually without even our knowledge or consent. Other than that, Randall's business has always been by word of mouth only, and good reputation. The question below adds more to this thought about learning, so please read that too. Question: I would like to learn more about the whole philosophy of this trust. Answer: thank you for showing so much interest, and I'm glad you wish to learn. However, Randall and I have chosen to go a different way than most common law trust purveyors, where many of them get overly wordy and complicated and develop it into a business and almost an academic institution. We have preferred to take more the spiritual approach, which is to keep it simple, concentrate the best of all approaches into a shorter form, free up the user's time, and leave more time free for spiritual practices and quality time with the family. After all, money, possessions, asset protection, physical things, and all the concerns about them are not everything. You know that the meaning of life is much deeper. There are complicated websites and extensive common law seminars, books, and verbose speakers who will hold forth for hours about all manner of trust philosophy and so on. In the end, we observe that they end up providing no more real benefit than we do by keeping it simple. In fact, simplicity can be more effective than complexity and time-consuming learning curves. Question: I would like to know which banks in my area will open accounts for these trusts. Answer: forgive me for saying it this way, but that is an incorrect question to ask. The reason is that the willingness to open the accounts for these trusts is not determined by which institution it is. Since common law instruments have not been as uniformly understood by banks as statutory entities, it often more depends upon which employee you are speaking with in the bank, and what mood they happen to be in that day. It is really that subjective. One of the best ways to have a higher likelihood that the bank will open your account is if you have already banked at that institution for years, in your personal name or some business name. If the institution knows you, if they have long since done their KYC Know Your Customer on you, if they consider you to be an upstanding citizen and bank customer, and especially if you have developed a bit of a friendship with any other bankers working there, then they may be willing to open the account for the trust, even if they are unfamiliar with such trusts and wouldn't do so otherwise for someone walking in off the street. They may open the account because they know you will be the signatory, and they are comfortable with who you are. Further, if you have been following the global reset news, you know that there are powerful developments moving the entire world more towards a common law banking system. Therefore, it is increasingly likely that more and more banks will be more than happy to accommodate customers with common law instruments. In the meantime, if you need to approach an institution where you don't already have an existing relationship, then just walk in with the pages from the trust that Randall will have indicated you should take and no more, and ask them. If they say no, then they have probably done you a favor, because their very unwillingness to welcome such a virtuous relationship shows that there is something questionable about their own policies and practices. So, go down the street and try another institution. It only takes trying a few to find one that will say yes. We have never heard of anyone not being able to find an institution that will open the account. Remember as well that you can have checking accounts at other types of institutions, such as investment houses, securities brokerages, online payment processors, and credit unions. They too are known to have opened accounts for these trusts. Hence, you have other viable options besides just banks. Question: are there any other costs or fees besides the $1,500 setup cost? Answer: no. There are no annual fees or further costs or fees to be paid to Randall's trust, unless you engage him for any special consulting needs that are above and beyond the normal consulting he provides that is directly related to the creation of the trust and the commencement of your operation of it. Question: I am very interested in this and wonder whether a single trust could be set up for both my wife and myself? Answer: yes. The great thing about these trusts is not being subject to the millions of ever-changing statutes, but rather only to the everlasting and ever the same common law. You basically have limitless freedom and flexibility to design, adapt, modify, and operate the trust any way you like. As long as you don't use it to violate the rights of anyone else, you and your wife can be co-trustees, and you can make the powers, responsibilities, and privileges of each of you as specific or as general as you wish. You can also make her protector, who has the power to hire and fire trustees. Or you can make her manager, managing trustee, successor trustee, or beneficiary. Or, if you really want to give her complete freedom, you can set up an entirely separate trust for her and encourage her to be trustee of it. There are discounts for multiple trusts ordered at one time. One for $1,500, two for $2,750, three for $4,000. There are lots of ways you can go. The how of it is better discussed with Randall, the trust writer. My role is mainly just to satisfy your weather questions. Whether you wish to order such a trust, and whether you have the $1,500 to pay for it. If you have both the money and the desire to proceed, then the weather is complete. Then let me know, and I will connect you with Randall. Then he will take over the dialogue with you from there, and he will entertain all the how aspects of it with you. Question: can I put all my assets into one trust? Answer: you could, but it is not recommended. The traditional cardinal rule among all wealthy people who use trusts is, have a different trust for each different asset. Have one for each house, one for each car, one for each business, one for each investment, etc., etc. In the early 1990s it was rumored that the Rockefellers had as many as 7,000 of these trusts. The reason is, what if you were to put all your assets into one trust, and then some problem were to arise with it? All the assets might be at risk. It is rare and unlikely that the trust would ever be successfully attacked, legally, or that it would be penetrated. In fact, we have never once heard of that happening with the trusts that my friend Randall sets up. But what if you had made the mistake of appointing co-trustees who later became disagreeable with you? If a conflict between trust officers were to arise, could they take your assets from it? Again, these trusts are set up so ingeniously and so beautifully that their very design minimizes the chances of problems. The design is fabulous, and so if the trust is operated according to the guidelines suggested, and if you are not using the trust in dangerous or questionable activities, then it is extremely unlikely that the assets in it would ever be at risk. But the whole point of asset protection is to maximize the security of the assets. Thus, the traditional cardinal principle is, have a different trust for each different asset. Question: what is your feeling towards a private interest foundation as opposed to a trust? Answer: I have no particular opinion other than I generally prefer common law entities over statutory ones. In addition, please be aware that the kind of common law trusts that Randall sets up can operate as foundations. The only possible disadvantage I can think of is that if you are accepting donations and you want the donors to be able to write off their donations on their tax returns as tax deductible, then your foundation may have to be a statutory entity. I'm assuming that's what you are referring to in Canada as a private interest foundation. In the US, a 5013C can operate as a foundation and be tax exempt. But it is a statutory entity and thus is subject to a long list of regulations. It does, however, offer the benefit that donors to it can have their donations be tax deductible. If your foundation is philanthropic and will be giving donations rather than receiving them, then the common law trust that Randall provides you could be set up that way and will be far superior, in my opinion, because it would have no tax agency or government filing requirements and would therefore be subject only to the common laws. That is, don't lie, don't steal, don't violate the basic rights of others, etc. It would be free of the millions of ever-changing statutes legislated by politicians and lawyers every year. Or, if your foundation will be receiving donations, but you don't care whether the donations will be tax deductible for the donors, then too, the common law trust would be superior. Question: does the setup include bylaws and share setup of the corporate? Answer: the bylaws of the trust are in the indenture, in the corpus of it. They're not termed bylaws, but that's basically what they are. Shares of the trust are called units. These are all explained in the indenture and in the manual. However, the trust is not properly called a corporation. A corporation is a public entity that is generally statutory. That's why these trusts are sometimes called unincorporated business organizations. Question: is there an ongoing process as growth of the trust foundation needs? Answer: absolutely. That's the whole purpose of it. If there were no ongoing process and growth, expansion, then it would just be a dormant entity and have little or no purpose. Most users of these trusts add documents to the trust on an ongoing basis, recording every significant transaction in a 3-ring paper binder notebook and in the computer files. Guidelines for all this are included in the indenture and in the manual that come with the trust. Question: after the trusts are set up, can we move most of our money into the trusts from the RV? Answer: yes. It is best to have the trust set up prior to the RV and also the currencies exchanged into the trusts prior to the RV. If you have my partner Randall set the trusts up for you, then upon your request, I can also provide you a template document you can adapt for your trust called Beneficiaries Exchange of Foreign Currency to Trust. As you know, there is not supposed to be any capital gains tax imposed on any dinar or dong holders anywhere, but it is to be designated as a currency exchange and not an investment. However, even if the IRS does try to impose a capital gains tax, it would be totally inapplicable to exchanges conducted for currencies owned by these trusts, because they are exempt. That is, providing the exchange has been documented prior to the RV. That's why I recommend that the beneficiary's exchange of foreign currency to trust be notarized, to prove that the date of execution was prior to the RV date. Question: can one trust have the money in several different banks, or will we have to divide the money up into different banks and have a trust for each bank? FDIC has been bankrupt since 2008 and is no protection. Answer: one trust can have as many bank accounts as you want, in as many banks as you want. However, it is also recommended to have a different trust for each different asset. A separate note unrelated to the trusts, though, is that a much safer banking system is coming. Some say it is already here. The RV is just a part of this new worldwide system which is asset-backed and which would make FDIC much stronger, or even redundant and unnecessary. Question: can the trust invest and not have to pay taxes on the profits? You mentioned them as being 100% tax-free. Answer: yes. Exempt statutory entities like 5013 CS don't have to pay taxes either. But the difference with the particular design of common law trust that Randall sets up is that his trusts file no returns. To me, that is at least as significant, if not more so. The privacy, independence, freedom, and sovereignty that absence of sending in tax returns confers are priceless and unsurpassed. Question: after the RV, the U.S. Treasury will be closely monitoring where every dollar goes. Will this cause a problem? Answer: before the RV, the cabal has already been closely monitoring where every dollar goes, and has already caused countless problems for peaceful, harmless, and life-supporting people everywhere. People think reports are only issued for transactions $10K and above, but FinCEN, Echelon, and other systems have been tracking every dollar down to the penny in real time for years. The difference with the new system is that the tracking may continue, but the world monetary system will be in new hands. Hands that are more compassionate, more interested in alleviating suffering than causing it, more interested in letting people live free, and more in tune with universal law. So everyone who is harmless, who has the best interests of all life at heart, and who isn't planning to use their money to dominate, exploit, divide, conquer, parasite, violate, or abuse will thrive and flourish in the new system, uninterfered with, in complete freedom. I would say the only people who should be concerned about the tracking are those who plan to violate the ethics of the universe with their funds. Whether the funds are in one of these trusts that I am recommending or not, makes no difference in that respect. The trusts provided by my partner Randall are among the best on the planet, but even so, it's like having the best computer. It's still a neutral device. What is done with it depends upon the consciousness and the ethics of the user. One can have the best trust and still commit evil acts with it. That is exactly what members of the dark elite have been doing. They have been using these very same trusts. That's why they have not legislated against them, and will not do so. But the effects of their use of such wonderful instruments have been harmful to society. As you know, it is time for those of the light to use these very same instruments, of such advanced powers of asset protection for spreading the light and the good. Therefore, anyone using these trusts in that way should have absolutely no problem being tracked, being watched, and being recorded as to what they do with their funds. They can be proud of what they are doing and happy to be seen in the full sunshine of broad daylight. You will find with these trusts and with the educational orientation from which Randall and I come, that we stand with such strength in the law, and in our decades of successful experience with these trusts, that we have nothing to hide and are not very interested in trying to be unseen. The only thing that we keep unseen, really, is the corpus of the trust. That is never given to any agency or any bank or institution. Only certain pages from it are shown to open bank accounts, as necessary, and no more. The trust is not publicly recorded anywhere. It is this privacy of its content that is part of the reason for its strength of protection. But other than that, we do everything in the full sunshine of broad daylight, and have no worries about any tracking or monitoring. Question: how would you put a sole proprietorship business into a trust? Answer: Step 1. Follow the instructions in the trust manual for adding assets into the trust. Transfer the assets of the sole proprietorship into the trust via documents that you create and add into the trust notebook. In most cases, there is no wisdom in posting or recording these documents publicly. It is a private transaction. Step 2. Begin having all monies that were previously paid to the sole proprietorship now being paid to the trust. Step 3. Likewise, begin paying all expenses and expenditures that were previously being paid by the sole proprietorship now from the trust. Question: I have gone over the information you sent me about the common law trust. I also looked it up on Google and it seems great but also somewhat complicated, so I'll have to look it over again and see what questions I have. Answer: it is good for you to know that via Google you will encounter a sea of websites with all kinds of opinions all over the map about trusts. Very few of them are even discussing the exact type of trust that Randall sets up, and among those, none of them know about the superior legal simplicity, purity, and style with which Randall writes his. This is because his is private, and is not discussed on any website, except in one or two places where people posted my one-page letter about them. If you like absorbing a vast variety of opposing opinions, many of which contain disinformation or misinformation, because your intellect is huge and you can handle the controversies with ease, then fine, survey the Google landscape. But if your intent is more practical, and you simply want to have the very best and most user-friendly protection, with the lowest likelihood of any problems, it would be good to simply be grateful that you have already found the best. Don't confuse yourself by the others. Question: I wanted to ask you if you had a chance to ask Randall if he knows an accountant in this area. Answer: yes. Randall responded, saying, in the past, only had a tax preparer here. He is very aggressive with his work. Did my own accounting. Go with a reputable accountant, if needed. Yellow Pages. Or, just use a or, get a good computer program. QuickBooks. TurboTax. Question: would we need an attorney? You would almost never want to consult an attorney regarding the content or the functions of these trusts, because they are written under common law, whereas attorneys, by definition, usually specialize in statutory law. They are dangerous because they are brainwashed by it and will not only fail to be of help regarding common law trusts, but they can actually cause harm by their misunderstanding of them and disinformation about them. Therefore, it would be rare that you would ever want to consult an attorney regarding any trust business. If you do, it should focus on the transaction, whatever is the subject of the consultation, and not the content or design of the trust. Very little information about the structure of the trust should be given to any attorney, as little as possible. Question: has Randall created many common law trusts for residents, citizens of A. Canada, B. United Kingdom, C. countries in Africa, D. Central and South American countries, E. Caribbean countries? Answer: if the trust were a statutory one, I would need to consult Randall to find out specifically for clients in which countries he has created trusts, to answer your question exactly accurately. But the fact that it is not statutory, but rather is operating on the higher and more evolved plane of common law, means that it is not a necessary question for you to ask. Suffice it to say, Randall is a world traveler and has clients in many countries. Common law goes everywhere. Hence, it is not necessary to determine whether the trust is applicable to any country in particular. Question. From the info about the trusts, it seems that nothing on the trust documents created by Randall is treated as being confidential. It is accessible to whoever, while it is on the internet. Answer. All of the information in the trust is intended to be private and confidential, with the exception of certain pages which need to be presented to a bank to open a bank account for it. The list of those documents comes with the trust. Otherwise, none of the rest of the trust is ever to be presented to attorneys, government agencies, or other institutions. None of it is to be recorded publicly. Nevertheless, we are also not fanatical about secrecy or encryption on the internet. While it is true that trust documents emailed back and forth could be intercepted, we have never heard of that causing a problem for anyone. Part of the reason for this is that only the initial setup documents created by Randall are emailed. Later, whatever documents the client may adopt for placing assets in the trust and conducting other trust business are done by the client according to guidelines and templates Randall will have provided. Those documents would be never seen by Randall and never sent over the internet unless the client wishes to do so. For some reason, therefore they can, and should, remain private.